Good morning, everyone, and welcome to today's TPN webinar on what is easily our most requested topic, evictions. And it wouldn't be a TPN evictions webinar if I wasn't joined here today by Cilna Steyn, Managing Director of SSLR Incorporated. SSLR is an industry leader in evictions, eviction specialists, been in this industry for a very, very long time, so there is no better person for me to have sitting next to us to share knowledge with everyone at home. Also with us on the couch is TPN's own Rowan Terry. If any of you have ever phoned through to TPN to ask for any legal advice, the chances are you've probably had Rowan on the phone. Rowan is TPN's legal counsel. Welcome, Rowan. Welcome, Cilna. Nice to have you both here today.
Thank you so much for having us.
Yeah, very excited to be here.
It's a pleasure. And Rowan, you'll see, has got his laptop in front of him. And the reason being is because he has got this webinar open live on this laptop, and he has got a first-hand view of all of the questions that we hope you're going to be asking us today. Please log into your YouTube channel, and make sure that you are subscribed to TPN. That will allow you to be active in the chat. Please ask as many questions as you want. Today's going to be a very interactive session. Rowan is going to feed your questions directly to us here on the couch. So Cilna, we're going to go take the people at home through the process of evictions pretty much from start to finish. And I think a good place for us to start is on the issue of breach. So all evictions at some point start with something going wrong. So I think it's probably fair to say that most evictions are due to people not paying rental, but there's many other ways that a breach can come. Can you maybe talk us through some of the other options for breach, maybe a common question that's been in the industry about consecutive breaches?
Yes.
Yeah, can you just...
Yes, so that's, I think, Greg, I think it's such an important point to realize not all evictions are created equal. So your evictions that typically come from a lease agreement, breach of a lease, so be it non-payment of rent or any other fun one that I'll be talking about, there are a lot of other things, like you can buy a property from a sale in execution and the previous owner doesn't want to vacate. You can, for instance, buy a property and you haven't seen the property before and there are people living in the property. And those evictions are not based, obviously, on a lease agreement. Some of the more complex evictions, and why I say complex, the eviction itself is still the same, but for instance, if you buy a property from a deceased estate, and the heirs of the estate are now disputing who can buy this property, who can sell this property, massive fight. The eviction is then deemed to take a very long time, but actually it's not the eviction's fault. It's not payment for eviction here. It is actually the process that comes before the eviction. So why I love this conversation and this question is, when we talk about breach of a lease agreement, whatever kind of breach it is, you have a lease agreement and you have a clear point on cancellation and then illegal occupation. That makes an eviction simple. So, yes, typically non-payment of rent, multiple breach is one of my favorite questions. Because luckily, thanks to our gorgeous residential leaseback lease, we have a clause in the leaseback lease that deals with consecutive breach. So what we see is, because the Consumer Protection Act says if a consumer, so a tenant in our context, is in breach of a consumer agreement, a lease agreement in our context, you need to give him 20 business days to remedy his breach, and only when he doesn't remedy his breach can you cancel that lease agreement. It's not like give him 20 days notice that you're going to cancel. You need to give him 20 business days to fix the problem. Now the problem is, that tenant that continuously pay on day 19, we all know about that tenant. The thing is, it's not fair for the landlord to be stuck in an abusive relationship here, for lack of a better word, constantly, every month having to spend money to send a letter of non. The Act doesn't exclude the fact that you can contract around the types of breach that you have. It's very similar to something, for instance, looking at cancellation by a landlord if he wants to take occupation. The fact that the CPA doesn't deal with that fact doesn't mean the CPA excludes that provision, that actually comes from another piece of legislation, being the Rental Housing Act.
Exactly. And this is a conversation we had specifically on that CPA. It says that you may cancel a lease agreement when they have been in continuous breach for 20 business days, and then you cancel afterwards. But it doesn't say that that is the only method of cancellation that's allowed. There are other contractual means of cancelling a lease that aren't necessarily covered by the CPA. The fact that something in a legislation governs a particular scenario doesn't mean that it excludes all the other scenarios that are out there. Otherwise, that would be the only reason you would ever have to cancel a lease.
Exactly, and if that was the case, if that was the case, we wouldn't have courts having to interpret and extend legislation. Because legislation isn't set in stone as many people would like to believe. Obviously, some things are clear. 20 business days, clear.
Yeah.
But that's not the only option you have there.
Exactly, and if you're using TPN's residential LeasePack, the TPN lease has got clauses in it, such as that, where, as Cilna pointed out, you have 3 continuous breaches where you've sent a letter of demand and that letter of demand has been rectified. If it happens 3 months in a row, then you also have the option to cancel the lease agreement. And that brings us on quite nicely to the topic of letters of demand. And I'm going to throw to Rowan, who's sitting at the end of the couch looking at his laptop over there.
Yes.
Something that's important to note is that your letter of demand sets you up for success. And there are different types of letters of demand for different scenarios.
Yes.
So from TPN, we offer a 20 business day letter of demand, and we offer a 7-day letter of demand. So I'm going to ask Rowan now to explain to everyone, because I know this is a question he gets a lot on the legal help desk. Can you just explain the difference between the 20 business day and the 7-day letter of demand, and when you use which letter?
Perfect, absolutely. So it is a query that we get quite often and a lot. Cilna made mention quickly earlier of Section 14 of the Consumer Protection Act. Now, that particular section applies to fixed term agreements, but you need to determine whether your specific lease agreement will apply to Section 14, or Section 14 will apply to your lease agreement. Now, we've got a bit of an infographic that we've actually prepared for all of you. So if you fill out your feedback form, you'll get your attendance certificate as well as a copy of the infographic that you can keep, which shows you the diagram of exactly how to determine which letter of demand to use. So first things first that we look at is the term of the agreement. If you are running on a month-to-month lease agreement, then Section 14 will not apply because it's only applicable to fixed term agreements. So if you are on a month-to-month lease agreement, you will then proceed with a 7-day letter of demand. If you are on a fixed term agreement, this is now 2 months or higher, then you would tick your first box, and then you look at the next one, which would be the parties to the lease agreement. Exactly. Now, if your tenant is a natural person or a juristic entity with an annual turnover of less than 2 million rand, then the Section 14 of the CPA will apply to your particular lease agreement, and you have to afford them 20 business days to remedy their breach. And if they don't do that, then you would be entitled to cancel your lease agreement. But if it is a juristic entity with an annual turnover of more than 2 million rand, it will not apply, and you will then proceed with the 7-day letter of demand. We have got all of this on the bureau on our system, and we also have a few prompts that pop up to assist you into determining if you are proceeding with the right letter of demand. So if you need to send a letter of demand, sign up with TPN, make sure you are using the correct system to use the right letter of demand, because if you get that wrong, to start the process all over again before you've even gone to court.
Yeah.
And if I may hop in on that one, obviously through SSLR we see so many evictions in a month.
Yeah.
If that's all you do, you see a few of those. And the thing is, we've done, obviously, because we do a lot of evictions on the back of the TPN letter of demand, I can really say that the success in court with that letter of demand and the cancellation letter is 100%. It's the moment you try to get very creative with a letter of demand, it could be cool, except when it doesn't work in court. And what do you want? A pretty letter of demand that works, or just a pretty letter of demand? I don't know about you, but I like a quick, effective eviction.
Absolutely.
So Rowan gave you quite a lot of information there, but remember, he says that there is going to be an infographic that is sent out to everyone. Please, that feedback form is going to be posted towards the end of today's session. Make sure you fill that out, and then when that attendance certificate comes, you will also receive that infographic. It's a perfect size for you to print out and put somewhere on your desk, so that if you have any questions or any sort of hesitation of which letter to send, you can just refer to that nice infographic, and you'll be able to know exactly what you're going to send. Now, once you've sent your letter of demand, your time has expired. then is the point to send your notice of cancellation. One thing that I want to really enforce with everyone is that sending letters at the right time is vitally important. Your letter of demand, for example, if your lease says that rent is due on the 1st of the month, you can send a letter of demand on the 2nd. It serves you well to act fast.
Yeah.
People always think, evictions take so long, but if you've waited 3 months of having not received rent before you send a letter of demand, you're already 3 months behind. Act quickly, send your letter of demand fast, and then make sure you count properly. I'm gonna hand over to Cilna here because I'm sure she's dealt with people counting incorrectly before sending a cancellation more often than we probably have.
So I'm honored that I've shared an office in my life with the guy on the couch.
Yes.
As well. So Rowan would know exactly how life works
Yeah.
in an attorney's office. When you say to an attorney, count with me, it's a weird thing because attorneys are notoriously bad at mathematics. So when an attorney says to another attorney, count with me, we mean take out your calendar, ideally one of those big desks ones where
Always
you can
works
clearly
best.
see which days are public holidays. And why this is relevant is when we talk business days, 20 business days, we mean we start the day following the notice that you've sent. So first day out, last day in is the rule. So if you send your letter today, it's the 24th of Jan, please don't send it only today. It had to happen already about 23 days. So look at that mathematics from another lawyer. So 23 days ago already, but if you send it today, tomorrow will be day 1. You count every day, excluding public holidays and weekends. So when you run into a month with quite a few public holidays, make sure you mark them out and count them clearly. If you miss it and you cancel even one day prematurely, you run into a load of trouble because now you've effectively repudiated your contract. It is fixable, but I'm just going to say it's an embarrassing fix. To withdraw a letter and redo it because you've miscounted the days, rather ask a friend to count with you. That's why lawyers tend to count together, because sometimes you just miscount. Counting to 20 doesn't sound that complex, but the effect of getting that wrong, even by one day, is really a dismal and potential fatal error in your litigation.
I mean, as we said, when you're coming to evictions that people think take too long, if you get it wrong by one day, you're setting yourself back another 2 months again almost.
Exactly.
Because you've now got to withdraw your letter of demand, you've got to send a new one, and you've got to start counting from scratch. So doing it right the first time is what ensures you have an efficient, time-effective eviction. So one thing that's also important is with your letter of cancellation that you're going to send after you've counted correctly, a question that comes up a lot is how long do I need to give my tenant to vacate the property?
I thought I was reading your mind there because I
You
saw
were.
you heading there.
You could see the smile on your face come before I'd even finish the question.
I get that question so often, and the answer is simple. The moment you cancel a lease agreement, the person's right of occupation is cancelled and he is immediately in illegal occupation. There's a rumor in the industry that I've heard so many times that you need to give a month for people to vacate. That's, by rumor, I mean it is legally not correct and legally risky. The thing is, if you give somebody a month to vacate post-cancellation, you basically create a new right of occupation. You've just went through a 20-day business, very intensive, careful counting process to get to a point of cancellation. Just to create a new right of occupation doesn't really make sense. So no, when you send that letter, the reason why there is space in the cancellation notice for the letter is cancelled today, you have until X day to vacate, is for instance, in a situation where the property practitioner had a conversation with the tenant, it's a Tuesday, you're cancelling, and the tenant said, you know what, I'll be out by Friday. You just record that. My advice is actually always, and that's the way we do it in SSLR on our cancellation letters, is we say, the lease agreement is cancelled, you failed to remedy your breach. The lease agreement is herewith cancelled, you need to vacate the premises immediately. We don't want the people to just evaporate and disappear. We want to be able to commence eviction, and honestly, my advice on eviction is If the people doesn't make contact on that cancellation letter to say, I will be out by Friday or whatever the case might be, commence your eviction immediately, because like Greg rightly said, the moment an illegal occupant starts getting the feeling that you are still negotiating this illegal occupation, you are in for a long eviction, and that's what we're trying to avoid.
Yes, yeah.
And this is exactly the same with the TPN letter of cancellation. It will say you are required to vacate immediately, but no later than this date that you select, which can be a few days in advance. But that doesn't take away from the fact that you are still required to vacate immediately.
Exactly.
That's just an important distinction to make in terms of letters. One thing that also maybe relates a bit more to the letter of demand and the cancellation, but I think is still an important one to raise, is a question that I'm sure Rowan gets a lot as well, which is, I've sent a letter of demand for 5,000 Rand. The tenant has paid me 2,000 Rand. Does that mean that my letter of demand has fallen away? Partial payment of a letter and its effect.
Incredibly weird, Greg, because that question just popped up right
Did
now.
it really?
Yes.
I'm
yeah.
reading the audience's
face
mind.
was
I was like,
amazing.
wait a minute, hold on. Greg is telepathic. So partial payment of a letter of demand does not extinguish that letter of demand. So if there is any amount of money that is still outstanding after the 20 business days or the 7 days, whichever letter you've decided to take, you are still able to cancel the lease agreement if there is still money outstanding in terms of the letter of demand.
Absolutely. The only way to extinguish that letter of demand is for it to be settled in full and before that date. If you have a letter of demand that's settled in full, but you haven't sent out your cancellation letter yet as well, this could be potentially a rectification of the breach that you have to carry on. So again, the importance of 20 business days passes. On your 21st business day, then you send your cancellation. Don't wait between sending your letter of demand and your letter of cancellation. Make sure you're acting efficiently as well.
If I may on that one, however, if you've done your cancellation letter, so let's use both examples. You've done a letter of demand, outstanding rent was 12,000 Rand a month.
Yep.
Tenant paid 10,000 Rand. You watched this webinar, well done. And you've done your cancellation letter on day 21. You have the 10,000 Rand in your pocket. You do the cancellation letter. You say, thank you so much for that payment. Really appreciate it. Still the agreement's cancelled. You need to vacate the premises immediately. If the tenant then settles the full outstanding amount after your cancellation letter, please don't just carry on with the eviction. Hear me clearly. Send an email to say, Mr. Tenant, sorry, my friend, you were out of time. The cancellation letter was already sent. Thank you so much for that payment. That money was still due to me as the landlord. You do still need to vacate. And if you don't, we're still going to proceed with the eviction. Luckily now, I do have some cash available for that. I suggest if you say that in an email, just end it with a smiley face. But it's very important to know that settling after the cancellation letter is not going to undo the cancellation letter, but you do need to communicate. What we find in court very often is we stand in front of a judge and the judge says, I can see all this happen, but now the tenant is telling me he paid in full after you've done the cancellation, and you just proceeded with the eviction without any communication. Legally, we can proceed with the eviction. If we would get that order, we would still get the order. But the court's going to feel like, can we just communicate? Communication is key when it comes to an eviction. Just say, Mr. Tenant, thank you so much for your full payment. Still need to vacate, and if you don't, we're going to commence with eviction.
I'm lucky enough from the point that I'm sitting here that I can just about see the contents of Rowan's laptop. So I can see that he's got a document with a lot of questions from the audience, which is what I like to hear. So I think now is a very good point for us to have a couple of questions, because after we have this question portion, we move away from the part that the agencies and landlords can control, and we'll move on to the point where you've now handed over to attorneys and where it goes into the realm of attorneys dealing with the matter. So Rowan, what questions have we got?
Okay, so one from Jess Stephen we've got is that I've found that attorneys restart the letter of demand process all over again. Is this necessary, or can they utilize mine? Does mine have to be sent via registered mail, or is email sufficient? And I think something important here to say is that attorneys would restart the letter of demand process if your letter of demand is not sufficient for proceeding with legal action. And that happens a lot when people use their own letters of demand. You know, they make a Word document and include all sorts of wonderful things in there. That's why it's better to go to an attorney to proceed with your letter of demand. Come to TPN, we've got it on our system. It's so simple, and it is used to, like Cilna said earlier, it's accepted in the courts that those letters of demand are proper letters to proceed with eviction proceedings in court.
Rowan, can I hop in on a
Always.
very practical one there? So TPN, let me get very practical. SSLR, TPN letters of demand. As SSLR, we will never, ever, ever, ever resend a TPN letter of demand if the correct time frame was elected.
Yeah.
It does happen sometimes that you do send a letter of demand, a system-generated one, and the content of the letter isn't clear. The content must be very clear. A, what is the breach? What did you do wrong? Yes. B, what do you need to do to fix this problem? And what would the effect be if you don't? And we can't play with time frames. You have to say 20 business days. You can't say 7 and then maybe further 20 business days. It has to be clear, 20 business days.
Yes.
The other problem is very often that we see in letters of demand, even beautifully drafted letters of demand like the TPN letter of demand, if you have 2 tenants and the landlord only sends it to one of the tenants, those are the kind of things that would make us have to resend a letter of demand. What I suggest, and now I'm making this a help desk, TPN help desk problem, before you send a letter of demand, just quickly pick up the phone, run it by the guys from TPN, say, I have 2 tenants, I have 1 tenant. Let's make sure you get the letter of demand right. Then we don't need to resend, and make sure you don't use an overly creative letter of demand. Clear, simple, and you shouldn't have to resend. But in most cases, if done correctly, an attorney is not supposed to resend a correct letter of demand, definitely not.
And for that TPN Legal Help Desk, I see it just came up on screen, but you can get in touch with us at legal@tpn.co.za for email as well, and we will try and respond to you within a day. That's what we will try our best to do.
Great. And then also, just like Jess asked, does she have to send it via registered mail, or is it okay via email? And yeah, I think the answer to that is just you need to refer to your lease agreement. You need to look at your letters and domicilium clause to see how notices should be sent to your tenants. It's so important. A lot of people don't read that, and they go ahead with how they want to serve their own letter. Your lease agreement will stipulate exactly what method of delivery you need to follow.
Thanks very much for your question. So we are also going to have our normal Q&A session in the last 20 minutes of today's session, because I'm sure there's going to be a lot of questions
There's
to go
plenty.
through. So if your question wasn't answered now, we will try and get to it in that end portion. Okay, so now you've done your letter of cancellation. Your tenant is an unlawful occupier, and now the time comes to go to the attorneys, SSLR Incorporated, and get your eviction done through an attorney. Something that is important to know is that evictions is really a case of please do not try this at home. It is a very technical process, and it really does require specialist knowledge. Even court by court, your process is going to be different. So it is vital that you have someone that has experience in eviction specifically, and you go to the right people to ensure, again, that you are being efficient with your eviction proceedings. So Cilna, a lot of people maybe think that an eviction is, I'm just going to send the sheriff to the house to go remove it. But a lot more goes into it. So I think I'm not going to ask you to go through the entire process, because we'll be here all day and it would be fun to listen to. But I think that because you're not going to be doing this at home, a short summary of the process that you go through in the eviction application at court. Can you just give us a sort of summary of how that works?
Luckily, actually, Greg, an eviction is super simple.
All of them.
An eviction is super simple if you've been, training attorneys for 13 years on how to do it. So for me, an eviction is
There's the caveat.
extremely simple. And obviously, I work with a team of brilliant attorneys. I think my team is about 49 times more clever than I am, because they actually do evictions every single day. So an eviction, very important to appreciate the fact that you only commence an eviction at the point of cancellation of your lease agreement. Your letter of demand isn't part of your eviction process. Eviction starts post cancellation, ideally the day following cancellation. If the tenant doesn't make it clear he's going to vacate. Why so quick? Why can't we wait? because the moment a tenant feels like there's still room for negotiation, they will drag it out. It's a simple fact of life. So when we start, it is actually really a 13-step process from start to where the sheriff actually goes and do the eviction. So 13 things you need to know. I won't bore you with all 13. You're welcome actually on SSLR's website, www.sslr.co.za. There's a flow chart of time frame in detail. If you're that person, I'm that person that would love to see the whole thing. But just in very short, you start with a notice of motion, and I think this is a crucial element of the discussion. Many attorneys that doesn't specialize in evictions still want to use a rent interdict summons, so they start with a summons instead of a motion. Now, I won't bore you with the civil procedure law here, but the difference essentially is when the one gets opposed or defended, a summons has to go on trial. That is, even in the quickest court, that's going to be a year to 18 months process just to get to court. Where on motion, you go to motion court, and even when opposed, it shouldn't be longer than 4 to 6 months to actually be in court. Again, there are a few outlier courts, KwaZulu-Natal, even your high courts, both Pietermaritzburg and Durban, very, 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 very congested courts. So those are outlier courts, but the rest tend to be relatively quick. And we, for instance, very lucky these days in Johannesburg Magistrate Court, which we tend to avoid for a long time because they were slower, and they are like ninjas these days. We get those evictions in about 6 to 8 weeks. So that's exactly to Greg's point, the difference from court to court. So you can't say an eviction is going to take this long, but there are specific time frames. If you start with a notice of motion, your other party can oppose it. They have the right to do that. There isn't a thing in our law that, no, but he is in illegal occupation, he can't oppose. We have the audi alteram partem rule. Both parties are allowed to come and tell the story to court. What we essentially want to achieve with an eviction is compliance with the Prevention of Illegal Evictions Act. The essence of that act is to allow an illegal occupant the right to come to court and tell the court about his personal circumstances. Not to come and tell the court, you can't evict me for this and that reason. To come and tell the court, this is my personal circumstances. I am a women-headed household. I have an elderly person, a minor child, or disabled person living in this property. How court, considering my personal circumstances, also in line with Section 26 of the Constitution, can the court consider this, and what should we do, and how should we give this order so that this eviction order is just and equitable? Just because somebody is in illegal occupation doesn't mean we can just kick this person out and leave him on the street. But it also doesn't mean the landlord's going to have to pay for this guy for accommodation for a long time. There's a thing about what is just and what is equitable. And this is the things that the court need to know about. There are 2 steps that you need to do going to court. First, an ex parte application, where the court will tell the sheriff how to serve the notice in terms of Section 4.2. It's a summary of why we're doing this eviction. So how should we serve it? The sheriff must always serve these papers. And then 14 court days after that, at the soonest, can we be back in court for the actual eviction order, and then the court will hear the case and will look at the papers. Remember, we're on motion, so you as the landlord wouldn't have to stand in court. I'm sorry, ladies, you're not going to run into Harvey Specter at court. You're going to email your attorney, he's going to go to court. It's pretty boring, but it's a very effective method of getting it done, but you don't have to get into a witness box and get all sorts of evidence. Nobody's going to jump up and be like, I object, and it's not as exciting as you think.
It's not how it looks on TV. No.
Yes.
Something that's, I think, important to know as well is that you've mentioned a lot of phases that this application goes through. Something that's important to note and a question we get a lot is with evictions, they're costly, they're expensive, there's a long process, and all of that incurs legal fees. Remember that at every phase of this application, there's a chance to negotiate and have that tenant ex-tenant vacate the property and avoid the next phases of that process. So when you're looking at the costs of the eviction, it could be a very small amount if you send your notice of motion or even before the notice of motion, and then they vacate the property. Whereas if you go through this whole process that you're mentioning of it being opposed, it having multiple affidavits going backwards and forwards, and then you have to stand up and argue in court on the day, that's when your evictions potentially get a little bit more expensive. But every good attorney is going to try and end this process as soon down the line as possible in order to save you the most on legal fees and to make this eviction run in the most smooth and efficient way possible. I just think that's an important thing for people to note about the cost that's involved with eviction proceedings.
Exactly, and if done correctly, if you do your letter of demand on the 2nd of the month, you cancel on day 21.
Yeah.
We see in SSLR, in all the evictions that we're doing, if done correctly, on the moment that you can take the next step, if we step in and we commence phase 2, which is your notice of motion being served by the sheriff, that's going to cost at line less than 15,000 Rand. 60% of the evictions that we do, if it's done that quickly, on service by the sheriff, the tenant then realize, well, Greta, that's a legal term.
Yeah.
And it's Dutch. I need to vacate, and they vacate. So the truth is, then for less than 15,000 Rand, 60% of illegal occupants vacate.
Yes.
It doesn't sound that scary to me.
And I can confirm that as well. When I was in practice in KwaZulu-Natal, it was exactly the same. You get your letters of demand, the cancellation comes. As soon as people tend to see that court that's at the top of the page and what looks like a very formal court document, that tends to scare people out of the property quite quickly.
Exactly.
So it is vital to start the process and get it going. And at the very least, you can potentially get the people out at that notice of motion phase, and then you don't incur more.
Yeah.
So,
Sorry, just
Of
interrupt
course,
there. We
please
do
do.
have a question there, which is what could the eviction process cost? I don't know if Cilna, you want to go into obviously tenants who then receive the notice of motion and they don't move.
Yes.
What would the cost implications be on for those type of?
So there I openly brag about SSL. I think we are one of the only firms that is very clear, and every phase, like I said, we break it up into 5 phases. You can do phase 1 yourself through TPN, being the cancellation process. We pick up from phase 2 where you start. If you do phase 2, 3, 4, and 5 through SSLR, we have an all-inclusive upfront payment per phase, so you know exactly what it's going to cost. You're welcome to contact SSLR to actually get our full fee schedule. But Rowan, to answer your question, if you have to do phase 2 through 4, where you get the order, in most cases, we don't actually need to send the tenant. It's going to cost around 30,000 Rand to then get from cancellation to court order. Your eviction, if we have to send the sheriff, depends very much on the sheriff itself. But 30 to 45,000, even if the sheriff has to get involved there, is the typical ballpark figure. But if you do something, very often you are supposed to be able to quote an upfront number and know exactly what it's going to cost your client.
and again, evictions aren't necessarily one size fits all, so there are variables that might make your matter slightly different to those. So it's not they don't all exactly the same.
Exactly.
Something that I think is important to know here is that as an agent or a landlord, you have now handed over your matter to attorneys, and now you're at this weird point where you kind of have to sit back and do nothing. And patience is very important. So there's a couple of don'ts that happen in the industry quite often, which I'm gonna go into in a little bit of detail.
I know where we're going with this.
There's a couple of them. And we'll start with the most obvious one, which is changing of locks, cutting of power, cutting of water, anything that removes any enjoyment of the property. I promise that if you do something like this and you're impatient, you're only going to do bad things for your eviction process. As soon as a magistrate or a judge sees that you have done something like this and you've taken the law into your own hands, they're going to be a lot more sympathetic to the unlawful occupier's case, and you're probably going to be waiting a lot longer for the date that the judge will give for them to vacate the property. So please, once you've handed over to attorneys, don't do anything yourself unless you have run it by your attorneys first. Let them go through their processes and let them get the matter to court and do everything legally.
Journal your frustrations. in hard copy,
Yeah.
not on social media.
Scribble them down on a piece of paper and
Yes.
throw them into the braai on a Friday night.
Yeah.
So that's the best way you could do it.
Perfect advice.
So then on a little bit more of a niche side, as not just the changing of locks and cutting off power, I want to talk a little bit about a billing that agents do, because this is a very important thing that maybe sometimes gets overlooked. So you've handed over to attorneys, you are past the point of now we're going to an eviction, and you're getting towards the 25th of the month, and the time comes that in the past, you would have invoiced them for rental. Cilna, maybe you can explain why this is not necessarily the thing to do.
So post cancellation, you are still allowed to invoice. Just make sure you change your line item from rent to holding over damages or damages. If, however, you've done the letter of the bond, we get to the 25th, you haven't done your cancellation letter yet. Brilliant. You're welcome to invoice. Not a problem. You invoice still for rent. Up to the point of cancellation, it's rent. Please, 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 I'm really begging here. Do not resend a letter of demand. You can invoice while that previous letter of demand is still sitting. Invoice, yes, I know the amount's supposed to increase, but don't worry about it. Let's first see what the action is on the previous letter of demand. The moment you resend a letter of demand, you're restarting your 20 business days. Once you've cancelled, you can invoice, make sure it's holding over damages and not rent. We don't want to create a situation where you accidentally, tacitly reinstate your lease agreement. Very important.
Exactly. So if you invoice for rent, rent implies that they have the right to still occupy that premises, which creates that implied lease agreement, which is an argument and a defense that can be raised in court. And so just for a little bit of clarity there, a holding over fee is effectively a damages claim for the rental that you could have got from another tenant if that person that is in the property wasn't in the property. So that's the distinction in what you're invoicing for. Rental, you have a right to occupy this property. Holding over fee, you don't have the right to occupy this property. I could have made money from someone else. I haven't, so I'm claiming that from you. So be very careful with your line items on your invoice, as it could have dramatic effects again for your eviction process. I'm glad we touched on that. That's something that doesn't usually come up too often, that is important for people at home to know. Okay, so we're moving towards the end now of the more formal parts of the session. But one thing that I want to sort of point out is that quite often when it comes to this entire situation where things go bad, is that prevention can be better than a cure quite often. So if you haven't already done so, please subscribe to the TPN YouTube channel. Go back into the history of our own videos and look at the videos on how to vet your tenant correctly, how to place a good tenant, look at all of our products on rent check, and ensure that you are placing good tenants in your property. Obviously, things like global pandemics happen and people's financial situations may change, and that may lead to someone who previously had an excellent credit check now falling on hard times and being in trouble and having to be evicted. But in the majority of cases, where you have properly vetted your tenant, you can avoid the situation of having to cancel and evict the tenant from the premises.
And obviously using the right lease agreement.
You met my next point perfectly.
And luckily, we know,
So if you haven't already, shop.tpn.co.za. There are residential lease agreements that are available there, authored by Cilna and SSLR Incorporated, and utilized and supported by us. We are both here to help you through that lease agreement if you have any confusion at all. But having a good lease agreement in place also gives you the maximum protection against when the worst happens and things go wrong. Another small aspect that Rowan did a great webinar on is tenant communications and relationships. Being upfront and having a good open relationship with your tenant, very, very important. If you have a good relationship with your tenant, chances are you can avoid the argument of having to go to an eviction at a later date if you can potentially negotiate your way out of the lease and negotiate the tenant out of the property. So if you haven't already, again, subscribe to TPN's YouTube channel. Go back and look at our old YouTube videos. There are a lot of hours of very important education there for you to pick up. So that is kind of now the end of our formal portion. I can see that Rowan's question page has now stretched to multiple pages.
Yes.
So
Yeah.
I think this last 20 minutes is going to be full up with just questions and answers. So Rowan, I'm going to hand over to you.
Absolutely. Thank you so much, Greg. So one question that I can see we've been getting a lot from all of our viewers today is, who pays the cost of eviction proceedings? Can you claim the legal fees from the ex-tenant? Can you claim the eviction costs from the defaulting tenant? So obviously, in terms of the TPN lease agreement, section 26 of the, I am correct, right?
I
Just wanted
believe
to
you are, the
confirm.
cost section, yeah.
Learned those sections like the back of my hand. Which that clause specifically states that the tenant will be liable for any legal action that is instituted against it. So in terms of that, you would then be able to claim a cost order when you institute proceedings, which obviously Cilna and SSLR all do with every single eviction that does get claimed. So you are able to then go and recover your legal fees from the tenant.
Can I be practical about it?
You can certainly be practical about it.
We will get the order, no doubt. No doubt about it. And we even get the order on attorney and own client scale. So cost scales are specific dictated scales on what attorneys can bill. Attorney and own client, like we do in the LeasePack, is actually the cost that you pay to the attorney. However, guys, the thing is, don't ever, my advice would never be to a client, institute proceedings, don't worry, we'll get the cost order, tenant's going to pay for it. We will get the order. But the fact that the tenant's already owing you 2-3 months rent, you've already possibly used your deposit in phase 2, because remember, the moment you cancel the lease agreement, your deposit does become available for use for anything due in terms of the lease agreement, which is then a rear rental, obviously. So you've possibly already used your deposit. Ideally, you should have, for cash flow purposes, on your eviction, if done correctly, big caveat. But the problem is, if you jump into an eviction with the idea that you will get that money back, it's going to be a sad, sad story at the end. Make sure, as a landlord, if you have 15,000 Rand as well as the deposit available for an eviction, when a problem hits you, that's all you need. You don't need a lot of money. You don't need massive insurance products. If you have that cash flow, you will be good on an eviction. Know for a fact that the chances of getting that money back from the tenant is few and far between. I know being this candid about not getting fees back from an attorney is not something you see every day, but it's a pleasure. Rather have that cash flow available and do not bargain on the fact that the tenant's going to pay for that, even if you have the order to try and get it sheriff, and it's a long process and very often less cost effective than what we would believe.
And again, if that tenant has fallen into arrears on their rental, the chances are it's because they're in financial distress. And you can get that costs order and you can have the right to go and take action against that tenant. But ultimately, if they've got a 0.00 bank balance, there's no money to recover. So you need to think of it as an investment in your future rental income that you are receiving. The longer you have a tenant sitting in your property not paying you rent, you are accumulating losses at a drastic rate. Whereas if you pay that money first and foremost, you get that eviction done, you get that person out of the property, then you can place a new tenant into your property and you can start making income again. So you are protecting your future investment by doing your eviction process.
Great, and then Cilna, a question for you. Does the attorney doing the eviction have to be in the magisterial district, or can you use an attorney of your choice?
Oh, you can use an attorney of your choice. Definitely, for instance, SSLR, we do evictions nationally. We can totally do an eviction in Kuruman while we are based head office in Joburg and obviously an office in Cape Town as well. But you use a correspondent attorney, so it's all about service address. Service address has to be within 15 kilometers radius of the court that you approach, whether it be High Court or Managed Court. But we have a beautiful network of correspondent attorneys, and don't worry, it doesn't shoot up the costs. Obviously, a good attorney is supposed to have negotiated rates with correspondent attorneys, and you can use any attorney. Like I said, using any attorney might not be my advice. It's I don't know about you, but I would probably use a cardiologist for open heart surgery.
Yeah, definitely.
I'll leave it at that.
Definitely. Then we have a lot of questions about the actual cancellation process, which I think is quite important to do. So for instance, we have a question here that says, do you have to send 3 letters of demand before you send the cancellation letter? On a month-to-month contract, must the tenant be out immediately after 7 days? And I think it's important to understand, like we said earlier, the letter of demand process, you have to determine which letter of demand you're proceeding with, 20 business days or 7-day letter of demand. And after that, if the tenant has not remedied their breach, you are entitled to cancel the lease agreement immediately. So often I get queries of, I've done a 20 business day letter of demand, then I did a 7-day letter of demand, then I did another 20 business day letter of demand, and the tenant hasn't paid for all of that amount of time. So it is to understand the process is going to save you so much time and so much money as well.
That flow chart is actually the one I spoke about, evictions on SSLR's website. I actually start with letter of demand.
Yeah.
So if you give the correct time frame, 720 business days, cancel, and then they need to be out. I think the 3 consecutive months it goes to blacklisting, but we're not blacklisting, we're evicting.
Yeah, exactly. And then another one here, which we said earlier, was must the tenant be out immediately after the 7 days on a month-to-month contract, if not fixing the breach of the contract. And it's important to note that you need to send out the letter of cancellation to effectively cancel. You can't just assume that the tenant understands after the 20 business days, it's automatically cancelled. The letter of cancellation needs to go out as well.
And something to also bear in mind there, it's slightly different. So 20 business days for the fixed term, but 7 calendar days if you're on a month-to-month. So just a helpful tip, it's not applicable in every situation, but if it's going to be divided by 5 in any way, it's probably business days. If it's divided by 7 in any way, it's probably calendar days, but just be careful when you're looking at your letters of which one to send. So yes, if you're on a month-to-month, it's 7 calendar days, so a normal week. And then on day 8, yes, you can send a letter of cancellation. You can instruct them to vacate immediately, but no later than whatever the date that you're going to select is. Whatever you do, do not give a date to vacate past the end of the current month that you're in as well. So if you fall on today being the 24th or even later on the 28th, at the very latest, put the end day of the month on your cancellation letter for the day to move out.
That's
just a helpful tip to make sure that you don't move into the next month's rental or holding over, just as a handy tip.
Great.
What's next?
Then we've got a few questions here as well. What if a tenant that pays his rent on time but doesn't pay his utilities? And another question we've also got there is, can you evict a tenant for outstanding municipal accounts? So I'm not paying their utilities, but they pay their rental each month.
Very important to know. It is all amounts arising from the lease agreement. So that includes your rental, that includes your utilities, all amounts that you've agreed to in your lease agreement. It is all arrears. And arrears means you can send a letter of demand. So if it's 10,000 Rand for rental and 2,000 Rand for utilities, you can send a letter of demand for that 2,000 Rand that's outstanding.
It does go back to your lease agreement again. What does your lease agreement say? Please don't assume your lease agreement has that. Obviously, if you're a TPN LeasePack lease user, fantastic, assume all you want. I promise it will be in there. But so the thing is, even if it's not municipal accounts, even if it's not money, even if it is, let's say, for instance, I'm thinking clause 17 now, tenant obligations, obviously talking about the LeasePack lease. Clause 17 dealing with, are you allowed to smoke in the premises? Are you allowed to have pets? Say, for instance, the parties agreed that you're not allowed to have pets. And now the next moment you have a cat and the landlord keeps on getting fined for the cat. Luckily, you have your rules attached. Everything is sorted. In terms of your lease agreement, it says you are not allowed to have pets. Again, 20 business days, please, please, please donate that cat to your cousin that's actually super into cats. And please do not have that cat there because we've agreed in the start that you're not going to have pets. If the tenant is then paying rent in full, paying utilities in full, being the perfect tenant doing maintenance, but the cat now, and I'm really an animal lover, it's a very important note on this one, and still the cat's there, you cancel the agreement based on non-compliance with any one of the other terms. But this is again why it's essential to know your lease agreement, because if you don't know the content of the agreement, you're not going to know whether you can actually cancel the agreement based on that action or omission from the tenant.
And again, if you're in any doubt that any thing that's going on in your property might or might not be a breach of your lease agreement, get in touch with us. We will help you with this. We will assist you in determining whether or not something is a breach, you can contact that email address that is on screen now, legal@tpn.co.za, and get in touch with us and ask the question. Don't, as Cilna says, don't just assume. You have people here who can help you.
So yeah, again, you two must be kind of telepathic here, because the next question I was going to ask is it possible to commence eviction based on non-compliance with homeowners association rules or other clauses in the lease agreement?
Perfect.
So
Answered.
fantastic. Answered. Luxlive Property Group, you are welcome.
One thing, just remember as well, attach those rules to your lease agreement.
We are telepathic.
We're all on the same wavelength today. If your rules are not attached to the lease agreement at the time that lease is given to the tenant, they are not binding on the tenant. The landlord will have to absorb all of those costs and all of those fines, and there will be nothing you can do because the landlord or you as an agent haven't given the tenant the information that they needed to know when they made the agreement. So attach it to the back of the lease agreement, staple it on there, bind it, glue it, whatever you need to do. Make sure they are there, that they can be read and are attached to the agreement so that they are binding and you can hold the tenant liable if they breach those rules.
What Greg just said was in terms of Section 5, subsection 8 of the Rental Housing Act. It's not a TPN SSLR thing. It's Rental Housing Act legislation we're talking here. So it's not us, I promise.
That's a non-negotiable. You have to do it.
Then also a lot of questions we've been getting today is what happens if the lease agreement has now been cancelled, but then full payment is received from the tenant? What does the landlord need to do if they want to continue with this tenant now?
Very important.
Yes.
Please don't just continue. You can, if say for instance, the previous option, you do still want to evict. This was now the 59th time that you had to go through this process. Tenant pays in full. Fantastic. Thank you, Mr. Tenant. We're still evicting you. It's been fantastic. Maybe get a few boxes to start moving. If, however, you do want to continue with that relationship, two things. A, this is true relationship advice. Just quickly think about what got you to the point of cancellation. Do you really want to continue with this? If you do tenant vetting and you know this tenant did what he did to you as the landlord, to the previous landlord, would you enter into this agreement? I'll leave it open-ended and you answer that question. Don't just go back to that because it's convenient and the tenant is there. Really think about it. You don't have to reinstate. If you do, however, want to reinstate, there was a reason. Tenant couldn't pay because he was out of a job and now he is re-employed. Something actually now makes sense why you need to go back to that agreement. Please make sure you use an actual proper reinstatement addendum. Again, a document part of the residential leaseback lease. It's one of the standard documents in there. Please do a proper reinstatement addendum. Don't just do a WhatsApp to say, no, all forgiven, smiley face, please sign. It's clear communication, but it doesn't reinstate your contract. So please do a proper reinstatement addendum to reinstate the same contract on the same terms for the same term as the previous agreement. Very important to do that properly.
Fantastic. Then one of the questions here from Elmarie Sneyman. Tenant has given notice to vacate at the end of the month. The lease has expired. They are not paying and they are not moving out. Must the owner still follow the eviction process here?
So the answer is very simple. Section 26 of the Constitution says that no person may be evicted or have their property demolished without a court ordering to do so after the relevant circumstances has been taken into consideration. The Constitution doesn't say only evictions on the back of a cancelled lease agreement or only evictions on the back of a sale agreement that went south. Any eviction, and an eviction in law is defined as the forceful removal of somebody out of a property, taking the right of occupation back forcefully, but you can't do it forcefully, only the sheriff can. And only the sheriff can do it once a court ordered the sheriff to do that. So it doesn't matter what happened. Even if you get to your property and people, it's your holiday home and you decided not to Airbnb or whatever, and the place was standing empty and now there are people squatting in your property. Even those people need to be evicted exactly the same as any other eviction. All evictions of people that's using a property for temporary or permanent shelter has to be evicted in compliance with the Prevention of Illegal Evictions Act. They look exactly the same.
And again, it's that important distinction that when you're looking at this legislation, it doesn't say tenant, it says unlawful occupier. And it's a big difference there. So a tenant is someone that has a right to occupy a property by virtue of a contractual relationship, be it implied or express or written. So anyone who is occupying a property could have been a tenant at one point and is no longer a tenant now. And that cancellation or ending of that contract could have come in any form that may have passed. But if you are occupying a premises in a manner that is unlawful, then the eviction process is applicable. And that's all of those examples that Cilna said to you already. You were an unlawful occupier at that point, that you no longer have the legal right to be in that property.
And then another one we've got here is the tenant changed email address that he had stipulated in the lease agreement. The LOD was sent to that specific email address. Attorney had to resend an LOD because the changed email address is not on the official lease. Is this correct?
It's an interesting one because you need to be very careful. So most lease agreements will have a notices clause that says that this is your email address that you have given as a domicilium. And that is the valid email address that you will send correspondence to. Most leases will then have a follow-up clause that says that if you want to change your email address, you as the tenant or as the landlord, whoever it is, have an obligation to inform the other party in writing of that change of email address. So you have an argument to make that, you did serve that document validly in terms of your agreement. Unless there was an email or something in the past that said, hi, by the way, this is my new email address. Please send all documents to me here, in which case, quite correct, you'd have to resend.
I do want to mention something, and fellow attorneys, please don't stone me for this one. Attorneys, you don't need an attorney to read a contract. If you look at the LeasePack lease, for instance, we draft in very simple, plain English. It's really simple. You, as the landlord, as the property practitioner, if you can read, I can promise you in most instances, you would be able to answer a lot of legal questions. For instance, that one. If your attorney says, I need to resend for this or that reason, you 100% have the ability to go through your own contract and say, explain to me if this is the clause here. Please don't be that person that Googles stuff. Just go into your lease agreement itself and talk to your attorney. Attorneys are people. And say, I don't understand why you need to resend if this clause says this. We live in an information generation. Ask the question. Attorneys must do things like go to court. You can't do that yourself. But you can definitely read and ask the question. And in doing so, you obviously learn. So sorry, attorneys, don't stone me.
100%. I'm very sorry to have to do this, but this is probably going to be the last question that we can take. We're getting towards the very end of this webinar today. So if for whatever reason we can't get to your question, please, you can email it to legal@tpn.co.za. All of the TPN attorneys will be on hand over the course of this morning to get to all of the questions that have maybe been missed. But Rowan, it's up to you to decide who the lucky last question is.
Oh, tough one. Also, just a quick thing, I have seen that the feedback form is out. There were a lot of questions going on about when was that going to be posted. It has been posted. Please make sure that you do complete it so that you can also receive the infographic, which I did receive a lot of questions on that as well. But the last one, I think, Cilna, it's going to go to you. Charmaine Deacon asked, must evicted people be provided with alternative accommodation?
Ooh. Beautiful question.
Big question to finish with.
Big
Perfect one to finish on. So usually the answer would be no. And the answer would always be never the landlord. The only time a landowner might be required to deal with accommodation is when he took too long, more than 6 months after cancellation of the lease agreement or after he became aware of illegal occupation. The court might say, you know what, this person has been here for so long. Your owner, you didn't commence your proceedings. Now you need to assist. But how our courts apply this rule of alternative accommodation is by simply extending the time period for execution of the eviction. So say, for instance, you dragged your feet a little on an eviction, you only commenced a year later or whatever, please don't do that. But if that happened, the court won't say you need to go and rent a property for somebody. That will never, ever, ever ever happen. There is no case law anywhere in South Africa where a landlord has ever been required to provide alternative accommodation. The court would simply say, instead of you having to vacate in a week's time, you can stay for 3, and the longest I have seen is an eviction where the court granted a period of 6 months on the back of a rental. When it comes to illegal occupants on, say, an open piece of land, there it could be a year or even more.
Yeah.
But on rentals, the longest time period that I've seen is 6 months. That was the case from about 2019. That was a bit of a shocker. In most cases, it's a month or at most 2.
Well, I think that is the perfect place for us to end. Thank you so much to everyone at home for joining us today. Cilna, Rowan, thank you very much. I'm sure we could sit and answer questions all day, maybe one day we'll do one of those sessions. But again, to everyone at home, thank you very much, and we'll see you at the next TPN webinar.
In today's online and accessible world, people are able to falsify bank statements, and identity theft is a very real problem. This is why TPN is proud to present verified online bank statements, where bank statements are requested directly from your client's bank and delivered to you on TPN secure platform. This check allows you to verify the applicant's actual income, verify the applicant's actual expenditure, prevent identity and documentation fraud, and provides convenience to applicants. Typically, you would request the applicant to provide supporting documentation, but TPN now provides a solution that allows you to do a full identity verification with the latest biometric technology. This enables you to request their bank statements directly from the source. Let's get back to reality. Michelle, how do you do this on the TPN system?
Rowan, it's as easy as ticking a box. Step 1, enter your consumer details. Step 2, verify income directly with bank. So once you have completed the process, the applicant will receive an SMS asking him or her to verify biometrics as well as consent to their bank details being shared.
Log on to TPN Credit Bureau to verify your applicants today. Another simple process that provides better data to make better decisions.